We're going to go ahead and get started here with the Law and Policy panel, the last one of the day. And we have three terrific panelists, and so I guess we'll just go in order here. Lisa Hajjar, and then followed by Richard Leo, and finally Lane Scheppele. So, great. Lisa.
Thank you. Well, it's nice to be at a conference on torture. Just to give a brief introduction to the topic of my paper, my paper's titled Lawfare, Viva la Litigation, and I'm sure it'll become clear quite soon what it's about. It's the issue of lawfare, and what I'll be talking about is just a little patch on the large, torture terrain, but this patch has some deep roots. So I'm going to assume a lot of things that I won't actually go into. So basically, debating what is legal in the interrogation and detention of war on terror prisoners is an American pastime, as this conference reveals. Torture isn't legal, of course, which is why President Bush continues to press the official soundbite that we don't torture. And plenty of people are willing to accept the president on his word by choosing to ignore abundant evidence to the contrary. Other administration officials have gone beyond short declarative sentences to explain that if we do it, it's not torture. The pattern is to deny allegations when they surface, to justify what can't be denied by stoking public fears, to fire whistleblowers and retire uniformed critics, to invoke state secrets privileges to impede investigations and dismiss lawsuits, to press for new legislation to immunize those responsible for torture, and to portray domestic critics of American torture as unpatriotic or even as terrorist sympathizers whose criticisms endanger the national interest. The highest-ranking torture denier advocate is, of course, Vice President Cheney. He appeals, in both senses of the word, to people who accept that the interrogation of enemy prisoners is a sovereign prerogative and that coercive and enhanced tactics are, at worst, a lesser evil to terrorism and, at best, an effective means of getting good information. In a February 7th speech to the Conservative Political Action Conference, Cheney said, and I quote, "The procedures of the CIA program are designed to be safe, and they are in full compliance with the nation's laws and treaty obligations. They've been carefully reviewed by the Department of Justice and very carefully monitored. The program is run by highly trained professionals who understand their obligations under the law, and the program has uncovered a wealth of information that has foiled attacks against the United States. The information has saved thousands of lives." Applause. There's one element of truth to Vice President Cheney's claim. The CIA program has been reviewed by the Department of Justice, and that's a major point of contention in the unending debate about torture. Now, revelations about torture and the legal rationale supporting them have galvanized people across the political spectrum and the civilian-military divide to articulate their commitment to the absolute prohibition of torture, not to mention its inefficacy and the damaging effects it's had on the nation's institutions and reputation. However, this bipartisan anti-torture constituency yields to myriad disagreements over whether what we do is legal and how it is to be decided. Since what we do has the imprimatur of the White House and the Department of Justice, less so the Pentagon since Rumsfeld's departure, criticisms are, in essence, criticisms of what is official. Some legal practitioners and intellectuals and activists have no compunction about criticizing any government, including their own, that authorizes tactics that constitute torture and abuse. Others, and especially active and retired members of the military, who have no predisposition or prior history of criticizing their government about national security-related matters, are in some cases discomfited that their principled opposition allies them with people with long records of criticizing the U.S. government. And needless to say, American party politics and allegiances also play a role in the discomfort in some critics. To give one example, in July 2005, when Republican Senator and JAG reservist Lindsey Graham read into the congressional record 60 classified memos by top JAG Corps lawyers that were harshly critical of the Pentagon's acceptance of your Office of Legal Counsel's reasoning, he said, "These JAGs, quote, are not from the ACLU. These are not from people who are soft on terrorism, who want to coddle foreign terrorists." Graham's reading of these memos into the record was itself a criticism of what is official. But his slur against the ACLU ignored that those JAGs and the ACLU are on the same side if the dividing line is between those who accept the legality of what is official and those who don't. Now, how does the Bush administration and its supporters of interrogation policies characterize criticisms and challenges? Lawfare. Although lawfare has a negative connotation, in the current context, litigation has become the means of last resort to try to restore the rule of law. And that's essentially what I'll be focusing on. So first I want to start with the multiple meanings of lawfare. On March 18, 2003, Lawfare, the latest in asymmetries, was the title of the National Security Roundtable convened at the Council on Foreign Relations to discuss, quote, the increased use of legal tools to combat American military might. The roundtable coincided with the start of the U.S.-led war against Iraq, but the discussion, as described in the summary posted online, included concerns about the then-year-old International Criminal Court and the, quote, widening gap between the legal culture in the United States and Europe. This widening gap refers implicitly to Europeans' increasing willingness to enforce international criminal law for gross violations by passing or using universal jurisdiction laws. The 1999 Pinochet precedent, in particular, demonstrated that a solid ally like Britain would not succumb to a sovereign immunity argument in connection with torture, even for a former head of state. The participants in the council roundtable are not named, but one of them was obviously Major General Charles Dunlap, because the definitions of lawfare offered in the summary are identical to those he presented in a paper at Harvard in November 2001, and again in a speech he gave in November 2007 at an American Bar Association conference. Dunlap has consistently defined lawfare as, quote, a strategy of using or misusing law as a substitute for traditional military means to achieve military objectives. In the 2003 Council Roundtable summary, one example of lawfare was the filing of human rights suits by Colombian peasants against military figures, which was compared to a decapitation strike because it might remove a military commander from active duty to contend with the suit. Another example, which appears in both the 2003 and 2007 cases, was the way enemies might manipulate American respect for the laws of armed combat by deliberately placing combatants among civilians, quote, to goad American forces into violations, which are then used against the United States in the court of world opinion. Now, the Colombian peasant example suggests that lawfare can mean any use of law that does not emanate from the military itself and may affect military members or operations. The Human Shields example conflates lawfare with the existence of the laws of war. In 2007, Dunlap diversified his examples to illustrate the potential for good lawfare, citing General David Petraeus' establishment of a rule of law complex in Baghdad. Dunlap's definition, which his examples illustrate, is simultaneously too narrow in its military-centeredness and too broad in its conception of the law to be analytically coherent. For him, anything that involves or affects both the military and the law is a manifestation of lawfare. Its goodness or badness, as he puts it, is like a weapon that depends on who is wielding it, how they do so, and why. Dunlap's 2007 address is titled Lawfare Today because he addresses the ways in which the concept has been used by right-wing officials, and I would say I use the term right-wing, I mean radical right-wing, and the term conservative would be inappropriate to describe these people, but right-wing officials and commentators to condemn critics of the Bush administration, including, and this is what particularly agitates Dunlap, uniformed and retired members of the military who've opposed the authorization and reliance on torture in the war on terror. For right-wingers, lawfare means any litigation or legal reasoning that is intended to restrict executive branch discretion or challenge the administration's prisoner policies. For them, there is no good lawfare, and the example par excellence, of course, is the Pentagon's 2005 National Defense Strategy conflating, quote, international processes, judicial fora, and terrorism. While Dunlap's 2007 address retains his military-centeredness, he applauds the military-civilian alliances that have built up since 2003 to work against torture and abuse. He writes, quote, concern by publics, NGOs, academics, legislatures, and the courts about the behavior of militaries is more than a mere public relations problem. It is a legitimate and serious activity totally consistent with adherence to the rule of law, democratic values, and for that matter, lawfare. The use of the courts is something I advocate as a vitally important lawfare measure. Now, Dunlap goes to lengths to praise the role that some JAGs have playing in criticizing the program and bringing cases that challenge the legality of the military commissions, among other things. And he berates the JAG's right-wing critics. He directs his most harsh comments to John Yoo, who, in a co-authored UCLA Law Review article, blames military lawyers for a, quote, breakdown in civil-military relations. Dunlap says, and I quote, "I beg to differ. JAG opposition to harsh physical interrogation techniques was a reflection of an analysis of the fundamental principles of human decency that underpin law in this country, not to mention around the globe." Philip Carter, a lawyer who has served in the military, although not as a military lawyer, endorses Dunlap's military-centered definition and agrees that lawfare can be a good thing. For example, he wrote an amicus brief opposing the government for Hamdan v. Rumsfeld. In a 2005 article in Slate, Carter writes, and I quote, "Truth be told, we have every reason to embrace lawfare, for it is vastly preferable to the bloody, expensive, and destructive forms of warfare that ravaged the world in the 20th century. First, lawfare has the obvious advantage of being safer than conventional warfare. I would far prefer to have motions and discovery requests fired at me than incoming mortar or rocket-propelled grenade fire. Second, our nation has developed safeguards to protect against the malicious use of its court processes. In short, our legal system today is far more sophisticated than the simplistic lawfare tactics of our enemies, and we should have more faith in its ability to protect us." Now, Carter's phrasing in that article illustrates the problem with, sort of when military members defend lawfare. Who are they and who are us? Carter's us are foremost the military and more inclusively the nation, and they are the enemy. In a blog entry on his blog Intel Dump written the following month, Carter recognizes the problem. The they going to court against the government include members of the military and thus are us. In this piece, he uses they and us interchangeably, and he writes, and I quote, "Those litigating the cases of Guantanamo detainees at this moment are not doing so in order to disrupt U.S. military operations. We are arguing these cases in order to uphold the U.S. Constitution and to make our government conform to those ideals which we as a nation have consecrated ourselves to. The retired generals and admirals who filed a brief in Hamdan v. Rumsfeld did not do so because they wanted to aid and abet America's enemies. Quite the contrary. They filed their brief because they wanted to help America retain the moral, political, and legal high ground in the war on terrorism, because they recognize that doing so is essential for strategic victory. We are not engaged in this fight because we hate America or want to help America's enemies prevail. We are engaging this issue in the courts because we care deeply about America and because we want this country to live up to its highest ideals, even or especially when at war." Now, Dunlap, Carter, and others who defend lawfare yield definitional ground to the right-wing emphasis on litigation. However, just now I would say as a non-lawyer, there's a problem with the whole lawyerly discourse on litigation in terms of the way use of the courts is discussed. Prisoners who have the status as enemies are in no position to do much of anything, let alone initiate legal action. People who are in a position to actually use the courts are not enemies. They're U.S. lawyers, both civilian and military, who have brought cases addressing the treatment of enemies, or innocent victims who are mistakenly treated like enemies, like Maher Arar and Khalid al-Masri. Now, right-wing critics of lawfare like you, David Rivkin, Lee Casey, and others have a very clear sense of who we and they are. Scott Horton is correct in characterizing them as lawfare theorists because their friend-enemy distinction is more complex than it might appear at first blush, and it rests on a combination of legal reasoning and partisan politics. First and foremost is the conflation of the president with the nation, which lends itself to assertions that criticisms and challenges to executive branch policies are anti-American and provide aid and comfort to the enemy. It's a short, slippery slope to interpreting such behavior as tantamount to terrorism. Second is the institutional subordination of the military, as well as Congress and the courts, to the unitary executive in times of war. Hence, efforts by members of the military to exercise institutional semi-autonomy, for example, using military law expertise to criticize interrogation and detention policies that reject the applicability of the Geneva Conventions, is condemned as lawfare in uniform. However, the good military, compliant and agreeable, is protected from the menace of lawfare by the shield and grace of the commander-in-chief's executive discretion. Third is the paradoxically simultaneous loathing of the courts and Congress as nemeses of the unitary executive, while favoring partisan litmus tests and cross-institutional solidarities to stack both with like-minded souls who accept that anything we do is legal because we are us, or better, help remake and reinterpret the law to legalize anything we, the royal we that is, do. These lawfare theorists argue that our enemies are using it against us. Since the it is litigation, their us and them dichotomy literally makes no sense because it reflects no ideologically or empirically unified groups of people, as Dunlap, Carter, and others have correctly pointed out. To be fair, some of them do have a very clear us in mind, which is literally them. One literal we are us is John Yoo, who suggests that the civil suit brought against him by Jose Padilla menaces not just him personally, but all Americans. In the first of his Padilla suit op-eds titled Terrorist Suspects Are Waging Lawfare on the U.S., or on us, Yoo writes, the 9/11 attacks on our nation's capital and financial center and the loss of 3,000 American lives placed the United States at war with al-Qaeda, a fact that Padilla's lawyers do not accept. Yoo also claims that the suit, and lawfare more generally, is undemocratic because it ignores the fact that the people gave George Bush the presidency, and thus any policies he has authorized are, by extension, an expression of the people's will. This people's will thesis extends to cover Yoo, a political appointee elected by no one. Now, I would come to the question of the issue of litigation. The anti-torture camp is so diverse because people with so many different backgrounds and outlooks concur that torture is absolutely prohibited. And the American courts have become sites of struggle over what is legal because the Bush administration has authorized policies that constitute torture and cruel treatment and refused to change course. And Congress has failed to act effectively to resolve the gap between what we do and what is legal. If anything, developments over the last few years, including the Military Commissions Act, the shakeups and showdowns at Guantanamo, and the waterboarding debate have made the question of what is legal a bigger mess than ever. This mess resonates within the anti-torture camp. As I would interpret the fault lines, some opine about what is legal in distinctively nationalistic ways, by which I mean that their center of analytical and interpretive gravity is American laws and institutions, to which the clarity of the prohibition against torture is muddied by the institutional roles of the authors of post-9/11 interrogation policies. Others, often people whose expertise on torture and or wartime interrogation and detention of prisoners predates 9/11, tend to opine about what is legal in more internationalistic ways by characterizing torture as an international crime and emphasizing the significance of international laws. To give one example, and I'm drawing on this from the torture list, so just very briefly to explain what the torture list is, it's a by-invitation torture chat space. Kim Scheppele organizes all torture all the time. It's absolutely fascinating. It includes members of the military, academics, legal practitioners, human rights activists, and so every minute detail about torture is debated. So anyway, to give an example from the torture list, there's been a vigorous and serious debate about everything, but about whether John Yoo is legally culpable or in some way culpable for torture. So just to give an example of the disputes about the debate, some argue that he can't be liable because of the immunity that officials enjoy while performing their jobs. This is often combined with the "it's not illegal to be stupid" argument. Some people argue that the function of the OLC, regardless of the stupidity or error of opinions from lawyers, is the source of legal reasoning. Others argue that legal opinions that advise the client, in this case the government, to disregard or break the law, which is what the torture memos and the war council sessions did, can't be legal. The no immunity for lawyers who break the law argument is backed up by the example of the Allied prosecution of German jurists at Nuremberg. This then raises related debates over what is possible and what is right, wherein some argue that the relevance of the Nuremberg example does not apply here because there is no willingness by prosecutors and courts to entertain such arguments vis-a-vis American officials in American courts. Hence, for the more pragmatic, nationalist-minded interlocutors, if the courts won't do it, it's wrong-headedly utopian and jurisprudentially unfounded to even advocate such litigation. Well, I would just conclude with I come in on the international camp, and I'll conclude with offering a few views about why lawfare is necessary and why the concept and its context must be internationalized. Torture is, among other things, a legal problem. It's a crime. Its prohibition is enshrined in many laws, some of which attach universal jurisdiction, and the disputed interpretations about whether and which U.S. practices constitute torture or cruel treatment have been so muddied by the passage of laws by our own democratic institutions that the courts are the only place left to sort out the competing claims. I certainly acknowledge that the political effects of American exceptionalism and legal parochialism, including the Military Commission Act's prohibition of U.S. courts to even reference international or foreign laws and court decisions, has significant constraints on the domestic pursuit of justice. However, the necessity and legitimacy of litigation cannot be determined by the actual or likely outcome of cases. Rather, the very act of going to court serves two important functions. It demonstrates a commitment to the norms and the laws that torture is always and everywhere illegal. And it creates a record for the future so that someday, when this era is assessed by historians, it will be known and understood that there were people willing to devote themselves, sometimes at the risk of their reputations and careers, to challenge torture and abuse. In the 1990s, when many authoritarian, military, and racist regimes around the world were being replaced by post-conflict democracies, including South Africa, as Albie Sachs so poignantly discussed yesterday, societies had to grapple with the question of whether torturers and those who abetted torture should be punished or amnestied. In many countries at that time, punishment was either precluded by concerns that prosecution would have a destabilizing effect in those precarious moments, or societies chose to pursue alternatives to legal justice, such as truth commissions. At that time, José Zalaquet, a Chilean human rights activist and former victim of the Pinochet regime, and Ari Nair, who was, had been originally with the ACLU, was back then with the director of Human Rights Watch, now with the Open Society. The two of them debated the question. I mean, they debated over and over again, so what I'm describing appears in many sources. Zalaquet argued that society should decide, not just the victims of torture. And let's say he himself had been tortured and was very empathetic to victims of torture. But he said that if there was a democratic desire, by which he meant a majoritarian desire, to amnesty violators, that this was a legitimate outcome. Nair responded that justice is not democratic. For him, the universality of laws and norms meant that the whole world, not just the national state and society, has a stake in the prevention and punishment of torture and other gross crimes. I would argue, using the example of Pinochet, that justice can be democratic. Of course, he had given himself immunity for his torturous and murderous legacy, and then he went to England. When he was arrested in London, people who initially protested were not just those who supported the former dictator, but some of his Chilean victims who chafed at the idea that foreigners, Europeans no less, might usurp Chilean sovereignty by prosecuting the country's past leader abroad. However, after Pinochet was found legally liable for torture, but returned home for health reasons, his aura had been shattered, and this enabled a new chapter in Chilean democratic justice, revising the country's laws and pursuing those responsible for torture in courts. Similar patterns have occurred across Latin America every year, bringing new cases against formerly immunized torturers. It was the use of universal jurisdiction in the Pinochet case that contributed to the strengthening of democracy in Chile, and this spread. The origins of the doctrine of universal jurisdiction trace back to international efforts to outlaw piracy and the slave trade. It was built on the idea that people responsible for such practices are enemies of all mankind. Torture attaches universal jurisdiction, as does terrorism, and its practitioners and abettors are contemporary enemies of all mankind. Domestic jurisdiction and the socio-political conditions that enable or prevent the practice of torture in any given country are important considerations, but torture affects the world. And when the most important state in the world tortures, and when national leaders, domestic courts, and legislators enable torture and impunity, it affects the world. It's important, I think, for more people to understand and appreciate universal jurisdiction as an expression of respect for the law, and to integrate that understanding in their own fights against torture here in the U.S., because every fight against torture anywhere in the world is a sign of faith in and respect for the law, and it's the good fight of our age.
Questions for Lisa? Well, I have one. A lot of the kind of discomfort or I guess opposition to lawfare seems to maybe have parallels, and I was just curious if you had looked into this, or if there might be something here, to some of the reactions in when criminal defendants were given sort of additional protections through in sort of the era of giving sort of increasing protections. There was sort of this idea that the bad guys are getting away, that the police are getting hung up on technicalities, and this idea that, that somehow the overarching goals that were so important for the police to achieve, they're being hamstrung in some way that was really problematic. And I wonder if there's anything sort of to be learned from that parallel at all, or if you think that parallel works at any level.
Yes, I think absolutely. The history, so the socio-political history of views about law are very much responsive to, changes in the country, and the, in a sense, the age of neoconservatism coming in the late 60s, early 70s as a kind of, blowback from the Great Society era, and one in which sort of the war on crime gets developed, was something that, on the one hand, there was a very powerful push to get tougher on crime, which has subsequently turned into things. And, so we've seen a very mixed record. While the kind of criminal defendant rights that were elaborated, in particular in the 1960s, were seen as part of the problem in terms of all that. So you get, in a sense, all kinds of discourses like hostility towards judicial activism and notions that litigation is undemocratic and so, especially around these kinds of questions. So these all, I think, play at the very basic level of those who are, critics of lawfare, the sort of right-wing critics. Because there's an argument about that the courts should serve a certain kind of function where you can more easily channel people who are determined by society to be criminals into it without these excesses of rights, but that too much lawyering is a problem, etc. But on the other hand, what I find particularly paradoxical, and this is also something that I've written about elsewhere. I mean, I actually believe that one of the problems. So anyway, I do believe that all of these things, the notion of the over-lawyered, as Jack Goldsmith had even said, the problem wasn't not enough law with 9/11. It was like the over-lawyering, and so the lawfare critics are certainly regarding all of this, as perhaps a parallel manifestation. However, one of the arguments that I, have made elsewhere is that. The notion that, if it's not a problem and people have no compunction about, thinking it's legitimate to prosecute and send carjackers to prison, torture is at least as bad a crime as carjacking. And so I've, made the case that we should try, people who are anti-torture might want to think about embracing the kind of tough on crime rhetoric and just simply expanding it in that way. Because I don't think that, for similar reasons I raised in a question earlier in the day, I don't think that the fight against torture gets much traction in this country for many reasons, but especially if you focus on victims. One really needs to focus on the crime and then, uphold the applicability of the law. So that's my suggestion. Davis's actions and the Hicks case, et cetera, with, Swift's activities and so on.
Yeah, I'm wondering if you haven't bought the Bush administration's definition of lawfare too uncritically. I can't believe I'm saying this about you, Lisa, but it seems to me that one of the really interesting things about the way the war on terror has been fought and the way the torture issues has been handled is how heavily lawyered it has been from the beginning. Right, that how many lawyers have been involved in this between Addington and you and the OLC, and that all of this was treated from the beginning as a question of legality, and that a lot of the Bush administration's efforts have been devoted to fuzzing the legality, right? But in legal terms and dealing with immunities and really, So what strikes me as being sort of interesting about lawfare is that in many ways what they've done is they projected onto their opponents what they're doing to themselves, right? Which is interpreting every question as a matter of personal immunity, of personal liability for each actor in government, which I'm not sure is the way anyone would have thought of it before they went to such great lengths to immunize themselves from it, right? And so there's this curious kind of weird legalization of it coming from the Bush administration, which has generated some of the legalism of the pushback.
Right. Oh no, that's why I actually think that the courts have become this, site for trying to deal with the kind of legalizing what is official. One of the questions, though, that you maybe would stress on this one, and wonder if you agree, we can talk now or later, is the it is the kind of torture is an international crime, and so the kind of national arguments that have been built up, and even the kind of critics of torture who sort of believe that the world of torture and the law begins in Portland, Maine, and ends in Honolulu. It's like that there's some sense that no matter what happens in this country, including the winning or losing of cases, the legal record, the rest of the world can judge, including possibly, down the line, universal jurisdiction type cases. It doesn't matter to a German what how esteemed the OLC is. In other words, those kind of nationalistic institutional arguments won't necessarily sell overseas, nor are they binding on the rest of the world.
Well, if I can just counter with that, what's so interesting to me is that the Germans, and for that matter, the Belgians who had universal, they always thought of themselves as much more limited in what they could do than the Bush administration imagined, right? Or that the power of the ICC, which, the U.S. was involved in all those negotiations, is very hard to bring a case for any American to be brought before the ICC, even if the U.S. hadn't opted out of everything. So there was this, in fact, this kind of building up of all these international institutions in the imagination of the Bush folks as being far more powerful than they were. And ironically, that's enabled both the human rights community and the Bush administration critics and those institutions to feel themselves more empowered because, so I think there's this kind of weird reversal, like that part of what the Bush administration's fear of law has done is to make this thing more legal and to make law more powerful in the discussion. It's just a...
Yeah. No, and in fact, I absolutely agree. And I think that's part of the fascinating thing. However, I actually, again, I've written about this elsewhere, I think that there is a distinct difference between international jurisdiction, of which the ICC is a manifestation, and universal jurisdiction. They are not two terms for the same thing. They're two extremely different things. The ICC, in my opinion, is useless. Universal jurisdiction is the best jurisdiction. So.
Question? Yeah. You in the back with a chance. Okay. Yeah, sorry, go ahead.
Here in Chicago, we've been dealing over the last 20, 30 years with systematic police torture of black suspects in the station house. And we have recently had some successes in dealing with it. And one thing we've been dealing with is the fact that there is no federal or local statute that covers the prosecution of torture. You can maybe get them for aggravated battery, or you can get them for something, along those lines. And one thing we've been working with some of the congressmen with is to have an actual statute, a federal statute that deals with official police or government within this country, torture, as defined by the United Nations. And one of the other things that we're dealing with is the concept of whether there should be a statute of limitations in that statute. Because if you look at torture along the lines of genocide or murder, then there should not be a statute of limitations in it. And the problem here has been nobody ever prosecuted, so all those crimes of torture are now outside of the statute of limitations, and the only investigations that are going on criminally have to do with perjury, obstruction of justice, and other kind of Al Capone type of prosecutions that you can do with these people that everybody, particularly in the black community, agrees should be prosecuted for these crimes, even though it's many years later. I wonder what you thought, and other people thought, about the concept of such a statute, and whether the statute of limitations should be more or less waived in a crime of torture, whether it be here in this country or statutes that deal more globally with regard to prosecutions of U.S. abusers.
Well, I'm not an expert on how the Convention Against Torture would bear on domestic cases, but I'm assuming that it is federal laws or the absence thereof that affects the treatment of prisoners. I absolutely believe that that's it would be a wonderful thing to have, would be a federal law prohibiting that kind of behavior with no statute of limitations. And one thing we can say is, this is something that gets patterned in, as a law and society person, laws are made when people perceive a need for those laws. And as tragic and horrible as the Chicago torture case has been, it may very well be a galvanizing moment to produce the kind of law that will be responsive to something like that in the future. It is, one can actually look in that sort of dynamic and dialectical way. But many people who work on U.S. prisoners and prison issues were, who've been doing it for a long, long time, were very agitated after, with, sort of the blow up of what occurred as the American torture debate, starting with the Abu Ghraib photos and saying, well, gee, that's not, it's at least as bad, if not that worse in U.S. prisons, the kind of treatment, et cetera. And I mean, that's not untrue. That's absolutely true. It's just that the laws governing foreign prisoners taken into custody overseas are different and in some ways stronger than the laws or, the kind of regulations governing the treatment of prisoners domestically.
Thanks again, Lisa.
Thank you.
It's an honor to be here. Thanks, and I want to thank both Scott and Martha for inviting me and for putting on this conference. Thank you very much. I'm going to talk about something that no one's talked about, which is not torture in the international context, but torture in the domestic context. And Mr. Taylor's question is a great prelude to my talk. My talk is going to be historical and hopefully relatively brief. So what I want to talk about is the third degree in American history, which roughly spans from the 1890s to the 1930s, although in Chicago it kind of continues to the 1990s. Much of this and other stuff is discussed in a new book I have that just came out a couple weeks ago, Police Interrogation and American Justice, by Harvard University Press. So I want to talk about the history of the third degree, the tactics of the third degree so that we see some of the parallels, the decline of the third degree and what replaced it, and talk a little bit about law, Flint Taylor's question in particular, the constitutional law, why there isn't statutory law, and some of the lessons, if there are lessons in this that for the war on terror. So let me begin by just defining the third degree. I think these definitions matter, and I think whether something is or is not torture matters, although the third degree, which I think is torture, doesn't use the word torture in the definition. And I say that because of something Darius, who has written about the third degree in his new book, said earlier. So the third degree was defined by the Wickersham Commission, the government commission that ultimately exposed it in 1931 as the employment of methods which inflict suffering, physical or mental, upon a person to obtain information about a crime. So you have both information and crime. And the tactics of the third degree, which I want to discuss in a moment, range from very physical forms of torture and coercion to more psychological forms of coercion, some of which we might not even consider torture. In the book, I describe these in 3 or 4 or 5, maybe 6 categories, one of which is blatant physical abuse. The categories begin to bleed into one another. There's no master logic to the categories, though I think it's helpful, particularly with respect to some of the categories in Darius's book, which came out after my book, or at the same time, I should say, after I sent this book to press. And his book, which is 3 times the size of my book, and a great book, is less expensive. So the moral of the story is published with Princeton, not Harvard. Okay, so throughout throughout my study of the third degree and the historical documents of the third degree, you see lots of blatant physical abuse: beating, punching, kicking. I just did a plug for your book, Darius. Clubbing. So much of the third degree involved what the term Darius uses in his book, scarring. The third degree was to some extent an underground and secret practice, but in some places it wasn't. It was very above ground. Police had a word for people they beat up. Hospital cases is what they called them. And journalists who observe the third degree had a vocabulary for what happened to people who went into police stations, shellacking, massaging, a workout, vocabulary to describe beatings that were very physical and left people bruised, bloodied, sometimes taken to court in bruised and bloodied states. And so part of the third degree was very visible. It wasn't entirely secretive and underground. Part of the blatant physical abuse also involved forms of burning or electricity or other ways of maligning the body and leaving visible marks. There were police detectives in New York who bragged about using baseball bats and splattering blood on the wall, or beating up hundreds of criminals with fists, blackjack, and hose. And I'm talking about newspaper articles that they wrote and books that they published at the time. So this is not like some sociologist happened to talk to them for a dissertation. The blatant forms of physical abuse were in the minority overall. At least that's the perception one gets from reading the historical records. The emblem or symbol of the third degree is the rubber hose, which we're all familiar with in American culture. The rubber hose really took multiple forms, and so the Wickersham Commission describes garden hoses, pieces of tires, blackjack soaked in water, and my favorite, sausage-shaped sandbags lined with silk, to beat people in ways primarily below the head that didn't leave marks, but yet were excruciating. Oh, and I left one out, the Chicago telephone book, which even at the time was quite big. And of course, there were other ways of administering pain that didn't rely on beating, but still were quite excruciating and were perhaps were deniable. And certain areas of the body that were strategically selected in order to administer pain that was deniable. Now, in the book, I talk about simple and orchestrated forms of abuse, and there were more complicated forms of abuse using electricity and some of the things that we've heard, the water cure, a form of waterboarding that, of course, predates the third degree in American history, uses of heat. More sophisticated methods of applying torture. And then there was the psychological component of the third degree, incommunicado questioning, losing suspects, the grilling and exhaustive questioning, and the blinding strobe lights, and the forced standing, early versions of sensory deprivation, at least in America. So lots of parallels to what goes on today in the international context. And of course, as we move from the physical to psychological end of the spectrum, forms of deprivation and threats and promises, including extreme threats, mock executions, threats of mob violence, which were very real in the South, of course, and other forms of threats that are ultimately threats of harm. So this is the range of the third degree, but there's a great documentary record from very physical to very psychological forms of torture, coercion, fear, manipulation, that raise some very interesting parallels that aren't often drawn to what is going on today internationally. Now, the part of the interesting story of the third degree is what happened, but perhaps the most interesting part of the third degree is its decline. How is it that this very entrenched practice, which was systematic, widespread, there were places where it was far worse, like Chicago, than other places, like Boston or Cleveland, but it was widespread, it was well-known, and the heyday of the third degree was the 1910s to the early 1930s, perhaps, maybe the 1920s. And so there's an interesting story about the decline of the third degree. Now, Scott gave a fascinating talk about the media. There was a sense today, there was a sense that the third degree was in the air. There were plays about the third degree. There are movies that featured the third degree. The third degree was in detective fiction. The rallying against the third degree was taken up by organizations in the 1920s, bar associations, grand juries. There was lots of muckraking journalism about the third degree. So there was a sense that this was known, this was in the air, not favorably portrayed, but not always unfavorably portrayed. And what ultimately, the story about the decline of the third degree is really about, I think, two things. One, the Wickersham Commission, which was a government commission in 1931, George Wickersham, former Attorney General, that I think it started actually in 1929, that they went across the country and systematically interviewed everybody who knew about police interrogation practices in particular cities, and documented extensively in 1931 in their report that the third degree, in its various physical and psychological forms, was rampant or widespread. And more than just documenting the practice of the third degree, they also documented the attitude, the police attitude toward the third degree. And there had been, as I've referred to earlier, many journalistic accounts, including books that were muckraking in tone but very descriptive, empirical books of reporters who followed police around and had wide access to police even as they administered the third degree, which reported many of the same things that the Wickersham Commission had reported. So the story of the decline of the third degree usually begins with the Wickersham Commission in 1931, and then there's a story about the constitutional law of criminal procedure, and particularly the 1936 case of Brown v. Mississippi and its assumed impact on the regulation of police interrogation practices. I want to say that the story, I think, is a little bit more complex than that, but the police reaction to the third degree was negative and pronounced immediately. The Wickersham Commission report was denounced as the greatest blow to police work in the last half century. At the 1932 meetings of the International Association of the Chiefs of Police, which sort of reminds me, as I was looking over my notes, Professor Paul Cassell of the University of Utah, then became federal judge, is now a professor again, once said the very same thing on 60 Minutes about Miranda v. Arizona. The police were angry in the main, and Zachariah Chaffee, who was one of the authors of the Wickersham report, wrote that the Wickersham report was greeted by the police with two answers which they regarded as conclusive. First, there wasn't any third degree, and second, they couldn't do their work without it. And Emmanuel Levine, who was a reporter for the New York Times, or the New York Daily News, who had been one of the privileged reporters to watch police administer the third degree in practice, I say privilege in the sense of having access to interrogation rooms where awful things happened, and where he ultimately wrote that the third degree is quite banal and ordinary in New York City at the time. In 1930, 1 year before the release of the Wickersham report, wrote that this is the police point of view, referring to the third degree. It is a necessary evil, but the police must not be caught in administering it. Okay, so the real story, I think, about the decline of the third degree is that in the 1920s, there was a group of progressive police leaders who were opposed to the third degree and who were trying to professionalize policing. And when the Wickersham Commission report came down, this created such a splash and so much negative publicity that the progressive police reformers and other progressives in the legal community, progressive elites, sort of came together, and the third degree quickly became perceived as quite a bad practice, both internally and externally to policing. The FBI was opposed to the third degree. J. Edgar Hoover emphasized scientific forms of policing, laboratory, fingerprints. And there was also a PR aspect to it, that professionalization of policing meant that they had to change their image. They had to be seen as the good guys. People sometimes died in custody in the third degree. They didn't want to be seen as brutes. Instead, they wanted to be seen as professional, as fair, as oriented to general norms of legality and due process, and also effective. That there was a widespread belief, and the Wickersham Commission has evidence for this, and this won't surprise anybody, of course, but the third degree resulted in lots of false confessions and unreliable evidence. And this had all sorts of effects on the criminal justice system. It's not just getting false confessions, but it was also making police lazy, over-relying on confessions, lots of police perjury, poisoning of the stream of evidence. The third degree was used not just on suspects, but also on witnesses to coerce statements. And so the third degree was seen as a problem not only for confessions, but for the criminal justice system as a whole. The third degree declines unevenly but relatively quickly in American history, and so by the 1950s and certainly by the 1960s, it appears that the third degree is completely exceptional, that the third degree is no longer practiced. Although every decade we see some example of a scandal in modern America in the 60s, 70s, 80s, 90s, Chicago is the constant, of course, with many years of police torture in Area 2. But there have been scandals in Little Rock, Arkansas, scandals in LA with the Ramparts case, of course, New Orleans, New York, and elsewhere. So they're sort of episodic scandals. Sometimes they may involve a few officers or more than a few officers. But for the most part, the third degree is gone, and there is a success story and perhaps lessons to be learned. What I argue in the book is that the third degree has been replaced by psychological forms of interrogation that sort of rest on twin pillars. Again, Chicago is central to the story, as it is to every story, it seems, about domestic interrogation and confession, including false confession. The rise of behavioral lie detection. On the one hand, the lie detector and the various offshoots of the lie detector, and the belief that so-called scientific instruments could read people's minds, and more importantly, intimidate people who are being interrogated to think that that their minds could be read, and they could be exposed, and therefore had no choice but to confess. And then secondly, the interrogation manuals by Fred Imbaugh, notably former professor at Northwestern and director of the scientific crime laboratory inside the Chicago Police Department, which seems like a peculiar thing in the 1930s. And so you get the emphasis on behavioral lie detection, turning police interrogators into lie detectors on the one hand, and these etiquette manuals on psychological manipulation, deception, and perhaps even psychological coercion. There's an interesting issue about what exactly is psychological coercion. And I said the second part of the story of the decline of the third degree. I think the first part is the Wickersham Commission and the coming together of reform-oriented police chiefs and police leaders and also progressive, legal and other elites. The second part of the story traditionally is told in criminal procedure as the famous Brown v. Mississippi decision of 1936. Scott said something interesting, I think, about a 1926 Mississippi Supreme Court decision, if I'm remembering correctly. In 1936, the U.S. Supreme Court denounced what I believe was a 1931, although it may have been maybe 1932, 34, Mississippi Supreme Court decision where they basically said whipping some African Americans was fine, right? But they repudiated the U.S. Supreme Court in 1936 in Brown v. Mississippi the use of physical force, and very clearly unanimous decision applied to all the states. And so what you see in the criminal procedure jurisprudence after that, as many people in this room know, is circumscribing what police can do psychologically to suspects, how long they can interrogate, under what conditions, what sorts of things they can and can't do, culminating in the famous 1966 Miranda case, which to some extent has completely displaced the law, the constitutional law of voluntariness that had initially been about police, or at least physical and then psychological coercion. So there's an interesting question there's a number of interesting questions here that I think are relevant to military and international interrogation issues as well. First of all, when you move from a regime of physical coercion to psychological coercion, there are questions of effectiveness, of course, and the widespread belief that the psychological methods are more effective, and that's what drove Fred Imbaugh and others within the police community to develop interrogation manuals. And they still say that, the firm that exists in their name, Reed and Inbaugh's name. So one issue is it more effective, and why is it more effective? But another issue is, where is the line between psychological coercion and non-psychological coercion, or put differently, psychological torture and non-psychological torture? And this raises a host of other, I think, philosophical and normative and legal and policy questions that could be the subject, of course, of another debate. The modern method of psychological interrogation is really, at its root, a two-step process psychologically. It's about convincing somebody that they're trapped, their situation's hopeless, there's no way out, all the evidence is against them, resisting is futile. On the one hand, breaking down their self-confidence, and on the other hand, giving them motivators or inducements to think that their situation will be better off, to avoid some sort of punishment. It's either now or never. This is your only opportunity. That if they don't confess or comply, what will happen to them is the worst possible situation. But they have this one opportunity right here and now, against the backdrop of all the evidence and the futility that's been developed, this one opportunity to improve their situation. Now that's a skeletal kind of reduction of a lot of research on the psychology of interrogation. Thanks. I lost my train of thought here.
Psychological.
Yeah, psychological interrogation, the skeleton of psychological interrogation. Right, that was the second step, sorry.
Third step.
Third step, right, make up a third step. Okay, so the question is, one question is this psychologically coercive, and what do we mean by psychological coercion? And if the FBI, I take it, or some members of the CIA, the people in this torture debate who say that we need to not use torture and move to psychological methods, if they ultimately prevail, where do we draw the line? What should be permissible in terms of psychological methods when we move away from physical methods? I guess what I wanted to conclude with is what, if any, lessons there may be from the domestic history of the third degree, its rise, its decline, what's replaced it, what the problems were, and how those problems were overcome for what's going on now. And I haven't given this a great deal of thought, so this is more in the form of speculations and perhaps recap as conclusion to the talk. I mentioned earlier that the Wickersham Commission report not only was a study of the practices of the third degree, but also about police attitudes. And one thing that is strewn throughout the Wickersham report are interviews and quotes by police who describe a war mentality, and it's their words, that this is a war on crime, and we've got to win this war. And I think that's one of the features that you see in regimes that torture domestically, obviously, as well as internationally. So there's an ideology, an ideological parallel there, and one of the success stories of overcoming the third degree is transforming police ideology away from that metaphor. And Darius mentions this in his book, there's obviously the problem of coercion being corrosive in that it has effects that undermine police investigation or any investigation. And so one of the lessons of the third degree, I think, one of the lessons of the third degree, one of the lessons of the decline of the third degree is that it's not just about the immediate situation of torture. There are more problems beyond the act of torture. It's obviously about contamination of evidence and corrosion of values and of function. I could speculate about a few other ideas, but I think I'm just going to summarize, or conclude rather, and then open it up to questions. The decline of the third degree is a remarkable story. It's a success story. It's a coming together of groups that were not natural allies. But it also gave rise to its own set of problems. Darius talks about in his book how regimes have become sneaky over the years, and perhaps one of the best ways to describe the decline of the third degree is, as I did many years ago in a paper, is as a shift from coercion to deception, and ultimately to sneaky or deceptive, or as I do in this book, fraudulent means. And again, that raises a whole set of interesting policy and legal and normative issues for discussion. And the point that I lost when I looked at the sheet that said I had 10 minutes left was that modern police interrogation, and I'll sum up with this point, modern police interrogation in America has really gone from torture, the third degree, in both physical and psychological forms, to a kind of plea bargaining. What really happens, the logic of modern interrogation today is really plea bargaining without attorneys. I think it's more effective. It's not perfect. There are interesting parallels and perhaps lessons for what's going on today. Thanks.
Yeah, I'm very curious about in your analysis if race comes up. I'm thinking in particular of, you're talking about the 1920s, 1930s, I'm thinking about the inclusion of, for instance, the Irish and the Italian into the police force. And there would be a tie-in, I think, with the sort of war on terror and torture in terms of Muslim Americans being incorporated into America. I'm wondering if that is there in the analysis of the decline of the third degree.
Well, the historical records that I reviewed when I was studying this and writing about it, of course, the South is famous for the third degree, but one of the points that's made over and over again is that the third degree occurred in the North and all across the country. It was widespread, not limited to, but perhaps disproportionately applied to African Americans. There was a stronger sense of ethnic identity in many of the police departments, police forces all across the country, and so that comes through. But I'm not aware of any good analysis of race in the decline of the third degree, and most of the focus would be on African Americans in the South and certain techniques that were terror techniques for African Americans, like lynch mobs or threats of lynch mobs. But I don't think there's a good racial history of the third degree from either side, police or suspects.
I have a lot of them. I'll keep the question short because we have a lot of One, can you give a quick theory as to why the third degree was more trouble in some places than others? What comes to that? Two, why is the decline of the third degree and the rise of deception and fraud in principle better? And three, what's the difference between, say, principles, practical and practices in Europe, where it seems like things perhaps not been quite as harsh? It's certainly now the police system, prison system there, and the police system is not so much there.
Well, those are all great questions. The decline of the third degree, I think that was your first question, right?
Why was it different in different places?
Oh, why was it different in different places? I think Darius mentions in his book that, I never heard this before, and it didn't come to me reading the materials that on the third degree that he did, that it declined unevenly, and correct me if I'm wrong, Darius, because there were internal controls and external controls, and the internal controls were more effective than the external controls being the press and law and muckraking, and the internal controls being somebody inside the institution. So that would be one good theory, or maybe it's more than a theory, empirically borne out.
I mean, the Irish police in Boston cleaned up their act, monitoring, and it really was a critical difference, was if the monitoring was internal or external.
But I mean, is there more of a theory to it than these guys did it and those guys didn't? Is it because the Irish all were of ethnic?
No, I mean, I think really, I mean, it's right. I mean, it really took leadership. It took the leadership of a series of professional policemen in the 30s who were committed to getting the real bad guys and not having to spend all their time running around talking to the press.
The second question that you asked is, I think, why is psychological coercion or psychological manipulation or psychological fraud worse than,
Why should it be better?
Why should it be better? That's a question for a philosopher, right? Well, presumably it doesn't inflict a I mean, I'm only begging the question, right? But the immediate difference to somebody who is a social scientist, not a philosopher, is that it doesn't involve the infliction of pain, and so it's not cruel and degrading and physically abusive. But again, we could have a whole conference about the more murky ethics of deception and fraud, and one of the strong arguments in the book is that's not such a good thing, and most scholars oppose it anyway. Then there's more pragmatic, you could talk about more reliable evidence, and professional norms are more likely to yield to due process and less likely to have scandals. There's all sorts of reasons one could use to answer the question. The third, staying brief, I don't know the answer to comparing this to Europe because I don't know enough about European history.
Yes. It seems to me the definition of torture is very narrowly medicalized at the current moment. It creates more pain in the way the definitions go. And yet people who are specialists and survivors looking at so-called torture, like some of the methods that have been used internationally introduced by the CIA, those effects, or the Kobler Center up in Evanston that deals with torture survivors, the so-called torture light, where you disorient people and other things, does much more long-term damage and very difficult to reverse. Now, is there any way the law can deal with measuring the long-term effects rather than just how it feels like at the moment?
Well, you say how the law would deal with measuring the long-term effects. I mean, I think that would be a question for empirical social science or medical science, and then perhaps there could be some legal response to that. I'm not an expert in that area, but I think much of the third degree was much more temporary than what's going on today, and so it presumably didn't leave as harmful effects, though I'm sure they were harmful.
I would contend that the third degree has not disappeared, and that it reappeared, and how it reappeared in Chicago was following the Vietnam War. That Burge and people like that came back from Vietnam with those tactics, with that attitude about dehumanization of people who, at that point, were Vietnamese, and then came to Chicago, and the black people in Chicago were in that dehumanization mode. And that was why the torture for the next 20, 25 years happened here in Chicago. We now are sitting in the Iraq War, and I fear that this kind is going to be, and it hasn't already, be brought back again. So I think we have to be aware. First, I don't think it necessarily disappeared before, but even if it has receded, that we have to be aware that those kinds of international and national may well happen again. The other thing I would mention is, I actually had Fred Imba at Northwestern, and I went to Northwestern Law School, and I deposed these detectives day in and day out about these interrogation techniques. I must have deposed 500 or 1,000 Chicago cops over my career about these various techniques, from torture to other kinds of psychological tactics. And I don't think that you can use the psychological Freddie Imba type of tactics without, it's a carrot and stick. And if you don't really have the stick, you're not going to have any effect with the carrot. So when the Imba technique is to kind of imply those kinds of, the Mutt and Jeff routine is in the other room, and that's what they often use. And if the Mutt in the other room really has no history or no reputation for doing the kinds of third-degree tactics, then the Jeff is not going to be as effective in getting to confession.
I think that from the perspective of somebody in Chicago, particularly from the perspective of somebody who's litigated a lot of these cases and knows them as well as you do, I can understand why you would say the third degree hasn't declined. But if you study the historical record and you see just how widespread and routine these practices were in the 1920s and 1930s, and how relatively uncommon they are today, especially outside of Chicago, I think there's no denying that something substantially different has happened. Your second point, though, is well taken, and I think Darius mentioned it earlier, that there's going to be a cross-contamination, I guess predictively, or in terms of hypothesis, when these veterans come back, they may be doing in the future what Burge did, those who become police officers. I think your third point goes really to the psychology of interrogation and perhaps speaks to some issues about what exactly is coercive, psychologically coercive, and is it inherently coercive?
So I wanted to underline actually both of those points. I think that we should keep in mind that one of the scandals of what happened here actually was that there never was a scandal that went on for 20, 30 years, that Flynn Taylor and a few other people just single-handedly made sure that we knew that over and over, that John Conway as a reader was the only person covering it, and everybody could be. And I think that the racial component, is huge there. And I think, that is maybe the point to take away from the point that it's a shame we don't know more about the demographics of the third degree. But I think that until we have some kind of outcry, things don't change, and we didn't have that. As long as it stays in the Black community, there's no pressure for change. And that, to me, is a lesson to take away from the Iraq War. That's the US-bound lesson, right? And that's what we need to be careful of. And the other point about the continuum, and this is not really something for you, it's more of a, I don't know, a frustration or a question about the conference, really. Torture, psychological coercion, torture. So just as we might say that killing is not always murder and that we have to have a legal definition for murder, we need a legal definition for torture. We're not saying that no coercion is okay. All interrogation is coercive. So, I've been a little bit confused throughout about, I think Eric actually, about whether torture is a description of what it is that is not okay and the way that murder is not okay, or whether it's a set of actual practices. And I think, it would be helpful to get a little more purchase on that, really. Some killing's okay, some interrogation's okay, some coercion must be okay, maybe, unless we want to outlaw interrogation entirely because it goes coercive.
Your point's well taken.
Not a question for you.
Yes.
Yeah, I have two questions. I'll just give them both, and you can decide if you want to answer one or both of them. One, regarding the psychological tactics, I'm just wondering if they've changed a lot in Miranda to maybe focus on keeping people from requesting a lawyer. From little I've seen, I've observed one film of an interrogation involved reading the rights, but then sort of hinting that maybe it would be better to just talk now. And I was wondering if that's the sort of the main tactic that would be used now post Miranda, to just try to keep lawyers out, or you haven't talked about. The other question was really a follow-up to something earlier Scott was asking about regarding whether there were there was an explanation about why certain regions or that other regions had a decline or earlier had so much use of third degree. I was just wondering if there's any correlation between tolerance of corporal punishment in school, tolerance of domestic violence, or whether this was somehow separate from everything else and just had to do with views about
I think your second question is great, and when I first started studying this many years ago, I wondered, particularly because of the social theory of Norbert Elias and the civilization of society, decline of certain norms of violence, whether there was a unitary phenomenon. But I kind of abandoned that early on because I really wanted to get to know my topic. So the second question, I just don't know. I think that'd be a great historical study. The first topic I know well, as do most criminal procedure professors, I think. So Miranda is a game that police have to get around, and the courts have made it very easy for police to get around. And the way they do that, in part, is by defining the interrogation as non-custodial, telling the suspect they're free to leave, and then not having to give Miranda warnings, or not giving Miranda waivers, since the Supreme Court says if you don't say anything, the interrogator, if they don't say, do you understand these rights or having these rights in mind, do you wish to talk, but they just launch into the interrogation, the suspect is constructively waived. Now, if there's some ambivalence, then they might do what you said, which is suggest that, well, you know, I can't get your side of the story, or I can't help you, or do you want to hear what I have to say? And this is very common, and the empirical studies that have documented this show that 95% people waive their Miranda rights. So when I was talking about the plea bargaining without defense attorneys, or the 2 steps of psychological interrogation, what I was talking about was post-Miranda interrogation. Miranda usually is meaningless in terms of stopping what's about to occur. It might slow it down momentarily, but it's largely irrelevant. There may be a tactic, but they don't talk about it in their manuals.
Thanks again, Richard.
The topic of my presentation today is in many ways about what is the American practice of rounding up detainees and subjecting them to torture and or cruel and human degrading treatment, doing not just to the U.S., but to the rest of the world. And in particular, it's probably appropriate that I come last on the program, because one alternative title for my talk could be After Torture, which is to say we've all sort of figured out over the last couple of days that at least the public rationale for torture is that governments that do it, in the U.S. in particular after 9/11, are looking for information. And what I want to ask is the question, so what do they do with this information? And does that in some ways feed back into the practice of torture to encourage it? And so it turns out, of course, that in most legal systems, coerced confessions, at least confessions that you know were coerced, have been banished. But nonetheless, that only begins to talk about what happens to coercive interrogations in court and elsewhere. Now, of course, the rationale for interrogational torture in the War on Terror is precisely that it won't be used against concrete suspects. The idea is this is intelligence gathering, it's not evidence gathering. And so there's this highly unstable line between intelligence and evidence that I think the justification of the practice of interrogational torture has been dependent on. And what I want to call into question today is the stability of that line between the two. Now, if you look at all of these folks that the U.S. has rounded up and held in U.S. custody, what's quite striking about this, first of all, is that, and this is, I think, where it feeds into what Lisa was saying earlier, that part of the worry about lawfare was the worry that these detainees, that the question was, what do you do with these detainees? And so there was from the beginning a sense that you couldn't trust ordinary courts to actually understand what these kind of exigent situations required. And so, of course, the constitution of military commissions, insofar as we know what they are, was meant to be, at least in the U.S. context, what you did with the folks who came through this process, that you would sort of send them out to the separate court system, where in many ways the distinction between evidence gathered for intelligence purposes, or information gathered for intelligence purposes, and information gathered for intelligence purposes could be blurred. This was at least the U.S. view. But if you look at what's happened in the rest of the world, it's actually quite fascinating, because even though the U.S. has now released a lot of detainees in its own custody, particularly, tens of thousands in Iraq, but even several hundred from Guantanamo, I know of no other countries that have put those detainees on trial. And a lot of it is because on the basis of what evidence would you put these folks on trial? Now, many of them have been put into preventive detention, or they've been disappeared in their own countries, or things of that kind, depending on the countries that people are sent back to. But once the U.S. rounds up and detains people and subjects them to these interrogation regimes, it becomes very difficult to process them through the ordinary courts. So what I want to focus on instead, because we don't have a lot of information about what happens to those folks, is what happens to others who were not detained. How has this practice of U.S. detention and forced interrogation affected trials of people who were not part of that archipelago of detention centers? And here's where I want to argue that the effects have actually been profound. Because if the U.S. indeed has in its custody, as it claims, a lot of the high-level folks involved in al-Qaeda and in other terrorist groups around the world, then it turns out every time any other country wants to put somebody on trial that comes from one of these groups, evidence that the U.S. has collected becomes something that turns out to be relevant to these cases. And this is what's happening in terrorism trials around the world. It's why I've called my paper actually the Metastasis of Torture, because what I want to argue is that this intelligence, this information which was gathered for intelligence purposes is now actually coming into ordinary trials in ordinary criminal courts in an astonishing range of places in the world. And so I want to add, in some sense, a fourth slippery slope to the three that Darius told us about this morning. Darius told us, that states that approve torture for a few victims wind up having that range expand. A few techniques, the techniques expand. A few exceptions, the exceptions expand. What I want to say is that there's a similar slippery slope that we can document that happens when you squeeze detainees for information for one purpose, that the purposes expand also, and the information comes to be used virtually everywhere. Now, how does this work? This happens in two different ways. So one is when somebody is put on trial for a terrorist offense anywhere in the world, and we have one U.S. case and a number of cases elsewhere, it turns out that statements made by detainees in U.S. custody are often found to be relevant. And the odd part about this is that almost always it's because, so far at least in the cases that have publicly come to court, so far it's because the defendants say, the U.S. has custody of this person who can tell you I was not part of this plot. And so the defendants ask for this evidence for exculpation, which puts courts in a real bind, right? Because on one hand, they don't want to say, oh, that's evidence acquired by torture, it's really unreliable, we can't let you use it if it might help you get out of this. And on the other hand, they also don't particularly want to use it. So there's a whole series of cases that fall into that category. And then there's a whole series of other cases where suspects are not put on formal trial precisely because this evidence that governments have about their potential involvement. The reason why the Moussaoui case wound up going in to sort of through normal judicial channels was because he was arrested before 9/11. The Bush administration decided very quickly after 9/11 that they were really not going to put any of these cases, or actually by about December of 2001, they had decided that none of these cases were going to go through the ordinary courts, but the Moussaoui case stayed there. And what happened? Well, Moussaoui was charged originally with being one of the co-plotters and co-conspirators in 9/11 because he was supposed to be the 20th hijacker. He was also charged with being a member of al-Qaeda and so forth. As the government began to learn that, in fact, it probably wasn't him, they kept the conspiracy for 9/11 charge, but the facts underwriting that charge changed. And so the facts that Moussaoui was put on trial for, or the allegation, was that his part in the plot was after he was captured to hide information from U.S. government officials so that they wouldn't uncover the plot, and this demonstrated that he was part of the 9/11 plot. Okay, and that was actually what he was convicted for. Now, Moussaoui's lawyers asked for statements from high-level al-Qaeda detainees, in particular from Khalid Sheikh Mohammed, or KSM, as he's called in intelligence parlance, who had claimed on international TV and has claimed now in his own confessions to have been the mastermind behind 9/11. KSM was captured in Rawalpindi, Pakistan in 2003, had been held in U.S. custody. We now know that he was one of the three detainees subjected to waterboarding and presumably a number of other harsh techniques. There were some others that Moussaoui asked for, and I'll explain a little bit later who they were, but primarily it was KSM. And even at that time, people were pretty certain that KSM had been subjected to techniques that were clearly under any definition torture. So Judge Leonie Brinkema, who really, I think, did an incredible job on this trial, despite the fact that she was being insulted and harassed from all sides, found that this was clearly relevant and potentially exculpatory evidence. If the mastermind of the 9/11 attack would say that Moussaoui wasn't part of the plot, there was no way you could say that wasn't relevant to Moussaoui's defense. And so at first she ordered the government to allow, to provide access to KSM on the part of Moussaoui, the defense team, and that the idea was to do a kind of deposition, a videotape deposition, through a remote video feed where KSM could be held in some remote location that was still unidentified, but where both Moussaoui and his lawyers, as well as the prosecution team, would have access to an ordinary examination and cross-examination. The government, of course, refused to provide access to Khalid Sheikh Mohammed or to any of the other detainees that Moussaoui had asked for, and so Judge Brinkema, I think, did the only thing that she could do, which was to drop the charges for which that would have been exculpatory evidence, which were all the 9/11 related charges. Moussaoui still could have been put away for a very long time on the basis of his membership in al-Qaeda, which he publicly confessed to in open court whenever given the opportunity to do so. In fact, Brinkema kept telling him, don't say that now, you can wait till later if you really want to do it. So it was clear you could have gotten a fairly long prison sentence. The government, however, wanted the death penalty. They wanted to preserve the charges, so they appealed her dropping of these charges to the Fourth Circuit. And the Fourth Circuit Court of Appeals issued what I think is truly a remarkable judgment, remarkable not only for what it says, but also for the fact that so few legal scholars have taken note of it. Essentially what the Fourth Circuit says was, yes, that's the usual remedy if the government's refusing to provide exculpatory information to the defense. The usual remedy is that the charges have to be dropped. But the Fourth Circuit says, this case is too serious to drop the charges. Which is to say, they already have the feeling they know what the evidence looks like before the evidence has been presented. And they said, the government has decided for national security reasons that they can't provide access to KSM and the other detainees, and we have to take their word that that's true. Okay, so they said, but it is also the case that Moussaoui can't get a fair trial unless he has access to this information, the good news. So they said, let's try to craft a substitute for an actual examination and cross-examination. And what we'll do is we'll have the government turn over, and calling them redacted summaries is only begins to describe it. What the government was willing to turn over were things that look like stipulations. If you've ever done evidentiary production, you know, if this person were to show up, he would say that, and then a bullet point list of points. There are no quotations in this. This list has been compiled by the government, which is, of course, not a neutral party in this case. There is no discussion about under what circumstances were these statements produced, or over how long, or under what kind of interrogative conditions were these statements produced. The Fourth Circuit looked at these things and said, the judge can work out how to get a further summarized, further redacted version to show to the jury of this, and that the thing that would preserve the truthfulness of this, or the thing that would preserve the integrity of these statements, was that the defense could work with the prosecution to craft which elements of these statements came in. Now, they weren't just allowing the defense to bring in the exculpatory bits. The idea was if this was a witness, then the prosecution would be allowed a cross-examination. So the idea was that the prosecution could also introduce, under the rule of completeness, for those of you evidence buffs, under the rule of completeness could also introduce other aspects of the redacted summaries that would tend to balance out the stuff that the defense was trying to bring in. Now, think about this for a second. This is all happening in an opinion that never mentions the most crucial word they might have said, which is hearsay. Now, the hearsay doctrine is much maligned. It's really complicated. It takes a full half semester to teach for all those of us who have taught evidence law many times. It's way too complicated. It looks like we ought to just junk it because it's too hard to understand and explain. Nonetheless, the hearsay rule is the main rule that actually prevents evidence acquired by torture from coming into common law jurisdiction cases. And how does it do it? It requires the live production of witnesses so that the jury and the fact finders can see somebody and whether they seem to be testifying under their own steam or under coercion, right? That's why you want the actual production of witnesses. As soon as you go to written records, especially written records produced by the government, you have absolutely no guarantee against the kinds of things that the hearsay rule is supposed to protect you from. And so it's remarkable in this Fourth Circuit decision that they never once mentioned the hearsay rule, while they are functionally carving out what I'm calling a national security exception to the hearsay doctrine. Okay? So what do? They actually say, and this is the more stunning thing, because you might say, those of us who've been, everyone in this room, wants to scream, what about torture? Or at the very least, coercion, especially with someone like KSM, whom we know has been waterboarded, and it was known at the time the Fourth Circuit decision came down. Here's a quote from the Fourth Circuit decision. Nothing in the government's submissions in connection with the petition contradicts our conclusions that those redacted the witnesses, I think it's who interrogated, judging from this, those who interrogated the witnesses have a profound interest in obtaining truthful information. To the contrary, we are even more persuaded that the redacted process, interrogation process, is carefully designed to elicit truthful and accurate information from the witnesses. The Fourth Circuit goes on. We emphasize that we have never held, nor do we now hold, that the witnesses' statements are in fact truthful and the jury should be so instructed. Instead, the jury should be informed that the circumstances were designed to elicit truthful statements from the witnesses. Okay, so what happens is that the case goes back to the trial judge. She crafts these statements. I actually have them. It turns out that it was not just KSM, but also al-Hassawi, al-Qahtani, who's now the 20th hijacker. Al-Qahtani is the guy who was dressed in a diaper and flown around for 30 hours being told he was taken to Egypt. He gets back off at Guantanamo. They interrogate him pretending to be Egyptians. So his interrogation is also known to be, shall we say, somewhat compromised. Khalad and Hambali, who are, again, two very high-level detainees, it would be surprising if they weren't subjected to the most harsh interrogation protocols that the CIA had. From all five of these detainees, 128 pages of summarized redactions come into the Moussaoui case. And these summarized redactions turn out to have a few paragraphs that say, oh yes, KSM says, I planned all of 9/11 and we gave up on Moussaoui because he was too unreliable, but we planned to use him for a second attack. There's about 6 paragraphs of exculpatory evidence and about 20 pages of the plans for the second attack that Moussaoui was allegedly involved in. When Hambali testifies, he says, well, you know, Moussaoui wasn't involved because he was unreliable and unbearable, but this is a quote from the summary, which is to say it may not be a quote from Hambali, but Moussaoui had dreams of flying a plane into the White House. Okay, now all of this is coming in, I have to just emphasize, as a written document over any hearsay objection, because remember the defense asked for this. That's why there's sort of no objection flying around in the courtroom, and at least as much of it is inculpatory as exculpatory. In fact, when the conviction of Moussaoui came down, even though it's really hard to claim that his participation in the 9/11 plot was very serious, I think from having looked at the record that the stuff that tied him most in to al-Qaeda and some kind of plot was this allegedly exculpatory information. This is now on appeal to the Fourth Circuit, but nobody's raising the torture point because the defense wanted it, they're not going to say it, and the prosecution is certainly not going to say, well, we tortured these guys so you can't use the evidence, so it doesn't come up. A very similar case came up in Germany, the Mutasaddiq case, and there was another one that was dropped, but there were 2 guys left over from the Hamburg cell that had plotted 9/11 that were put on trial by the German government for being accessories to planning 9/11. And here, the very same thing happened. There was one case that got dropped because the exculpatory evidence that the German government had, because they had all of these intelligence summaries, was withheld from the defense, and in one case, the case collapsed. But in the Mutasaddiq case, the exculpatory information was revealed by the time the case went up on appeal. This was a guy convicted of being part of the 9/11 plot. The appeals court voided the conviction and said they had to go back and do it over again, adding the exculpatory information that came from, again, high-level detainees. In this case, it was Ramzi bin al-Shibh and, again, Khalid Sheikh Mohammed. Again, high-level detainees subjected to the worst of the worst CIA tactics. Now, the German law, I won't go into it at great length. If you want to know, I can tell you all about it. German law is, in fact, more restrictive about admitting coercive statements. And it applies not only to coerced confessions, but coerced third-party statements and a whole variety of things. It turns out that, of course, they were also troubled by the fact that this evidence had clearly come from compromised interrogations. So what did the court say? Well, here's a quotation from the appeals court that looked at the introduction of these summarized redactions, the same kind of evidence that came in Moussaoui. The fact is not ignored here, this is translation of the appeals court decision, the fact is not ignored here that it is state agents of the United States, a country accused in the press of torture, who deny the division access to sources from which might be expected comparatively more reliable and in particular verifiable information than that available in press articles and reports of humanitarian organizations, which is to say, lots of people say the U.S. tortures, they're not helping us in figuring this out. However, a significant circumstance added to the inadequate evidence situation in this case is the fact that the forwarded summaries of the examinations of bin al-Shibh, Sheikh Mohammed, and a guy called Ul Slahi do not exhibit the one-sidedness of a universal incrimination of persons not in custody. which might be expected if torture had been used to extract information incriminating only certain suspects. In other words, and the opinion goes on, because the redacted summaries had some information for, some information against, it was a kind of on the one hand, on the other hand kind of information, they said, that can't have been produced by torture because that's not what evidence produced under torture looks like. So therefore, the German court was fine taking this into account because that kind of evidence could not have been produced by torture, and they've upheld the conviction, and now this guy is going to prison. So again, these are two systems that pride themselves on not using tortured evidence. Let me give you one last example, and this is from the UK, where the British government was using, again, the same soup of evidence acquired by the very least active coercion to detain suspects in a regime of preventive detention. And so there's now a system where the Home Secretary issues something like a security certificate. They can detain suspected terrorists, actually, as it turns out, more or less indefinitely, upon, quote, reasonable suspicion of the Home Secretary that a specific person is a terrorist. Now, there's judicial review of this reasonable suspicion standard, and there's a court called the Special Immigration Appeals Court, or SIAC, which reviews these determinations. So at least in Britain, there's some built-in judicial review, and SIAC is supposed to review the evidence on which the Home Secretary based the decision to detain to determine whether that detention is reasonable. Now, the Home Secretary, this is back in 2004, made some public statements that some of the people currently under detention might have been kept on the basis of evidence acquired by torture, and the Home Secretary asserted we have the right to put people under detention, even if the evidence on which they're detained was acquired by torture. We have an obligation to protect our citizens. So the case went up eventually to the law lords on the question of whether this SIAC, the special court, could use evidence potentially acquired by torture as part of the case that would determine whether the Home Secretary's judgment was reasonable. And so the law lords had to rule on whether tortured evidence was ever possibly used in any court in Britain. So even though this came up in a special court, the judgment is actually more broadly constrained. And many of you have heard about this judgment because the headline the day the law lords announced the judgment was, "Law lords ban torture." And in fact, the quotations are great. Lord Nichols of Birkenhead says, torture is not acceptable. This is a bedrock moral principle in this country. Lord Hoffman says, all seriatim opinions. Lord Hoffman says, the use of torture is dishonorable. It corrupts and degrades the state which uses it and the legal system which accepts it. Lord Hope of Craighead says, the law will not lend its support to the use of torture for any purpose whatsoever. Lord Roger of Earlsferry says, the history of the matter shows that torture has been rejected by the English common law for many centuries. Anyway, every single judge comes out with some statement like that. Lord Brown of Eton under Haywood says, torture is an unqualified evil. It can never be justified. Okay, so let's look at what they actually say. They say, no British court can ever use torture as evidence sustaining any judgment at all. However, there are a number of qualifications. So one is, in order for a statement to be disqualified as having been acquired by torture, you have to show on the basis of a balance of probabilities that that particular statement was acquired by torture. Moreover, the judgment completely rules out using either press accounts or human rights reports at showing that a particular state has a habit of using torture. And so from the way they say it, depending on which judgment you look at, it's at least conceivable that, for example, if you could show that a statement by Khalid Sheikh Mohammed had been made in some session other than the one in which he was waterboarded, it was probably okay. And so, but again, who would know? Exactly. So one of the problems we have here is that because, as we've discovered over 2 days, torture is always practiced in secret, it's going to be nearly impossible for any court to ever determine that any particular state was that any particular statement was acquired by torture. And so the lovely rhetoric turns out to be mostly useless at actually giving any particular lawyer the basis for excluding a statement acquired by torture. Moreover, and this is something we really haven't mentioned much over our conference, of course, in international human rights agreements, torture is usually paired with cruel, inhuman, and degrading treatment, which is equally banned. The U.S. Incorporation of that in domestic law tries to split the two apart. There's a lot of hair splitting between these two categories. And in Britain, there was a question about whether cruel, inhuman, and degrading treatment, evidence acquired through CID treatment, was also banned. The law lords in this opinion say, and by the way, our opinion applies only to evidence acquired by torture, not evidence acquired through cruel, inhuman, and degrading treatment, and they don't define the difference. Third, they say, so this is not a good decision I'm trying to get you to see here. The third thing is that they say, and moreover, because of separation of powers concerns, our decision only applies to courts. So courts may not use evidence acquired by torture, though they can use CID treatment evidence, but the executive can use any evidence acquired by torture because we can't tell the executive what evidence that the executive can use. And all 7 of these judges who said these great things also said it was fine for the executive to use information acquired by torture. And then finally they said, and then there's this question of derivative evidence. Derivative evidence is where somebody says, you know, there's ricin buried in my backyard, and then the police go and find the ricin. Can you introduce the ricin, right? The fruit of the poisonous tree stuff. Now, Britain in general doesn't have a doctrine of fruit of the poisonous tree, but in this context where evidence was explicitly acquired by torture, and this is what the court is ruling on, they said any derivative evidence is perfectly okay to use. Okay, so this is the law lords ban torture decision. And so what I hope to show you is this is just a couple of examples. There are other examples from Spain. Now Russia's got a couple cases coming up. That as other jurisdictions attempt to detain and prosecute terrorists, even though they're committed to using their own ordinary judicial processes, the fact that the U.S. has done this is now spreading through other countries' legal systems, both in the sense that decisions now have to be made about how far torture is allowed in a context where the assumption was it was never allowed, but now courts have to make these sort of distinctions between cruel, inhuman, and degrading treatment, torture, derivative evidence. All these things are now the object of judicial doctrine. And moreover, because of the fact that everybody recognizes that you can't do any of these prosecutions, even in a system that has not violated these rules, without, in some sense, getting this evidence swept into it. Courts are using this extraordinary situation of the war on terror and the U.S.'s use of torture to make exceptions in their own system which go beyond just the use of torture in that case. And so that's why I called my presentation the Metastasis of Torture. After the U.S. torture, even if U.S. torture were to stop now, it's still having this effect in legal systems around the world. And this becomes, I hope for anyone in the room inclined to do a cost-benefit analysis, this becomes one more reason not to do it. Thank you.
This is great. I have 40 now.
What's up with slow?
I was trying to think of other situations where I actually know, I was trying to think of this, and I was thinking, when you read the stuff by the Inquisitors, one of the really interesting things that strikes me about their work, if we can call it that, is that they had a fetish with paper. If it was on paper, it had to be true. And Harold Berman actually writes about this extensively, this kind of fetishization of documents. And I hear it now and again, and I've been getting glimpses of it. Your talk certainly identified it for me. But I hear, Director Hayden go on Charlie Rose and say, we have 9,000 pieces of paper, real tips. And it's like, if you can pile up the paper, it's truer, the higher that stat gets, right? And from waterboarding, I believe, was his specific instance, right? And, as a social scientist, I'm like, well, what do those 9,000 pages say? But from an anthropological perspective, I'm thinking, this sounds like fetishization of paper. And a kind of magical thinking that sets into play once you've loosened the boundaries of sort of regular kinds of checks on truth and reliability. And I'm just wondering if you want to comment on that.
Yeah, I'm not sure so much that, I like the idea of the fetishization of paper. I'm not sure that's it. I think what happens here is that the only way that information could be used is if it's sanitized, right? So that you have to detach the information from the practice of torture. And that getting it all in these redacted summaries, which again, don't use quotes, because there's also translation issues in the middle of all this stuff, which nobody's really talked about yet. Did jihad mean that he was worried about it, or was he going to attack the U.S.? Just to take one thing. So there's a whole bunch of issues about the movement of whatever has been said in the torture context to paper, right? And once it's on paper, it becomes possible for everyone to ignore how it was produced. And that, I think, becomes one of the incentives to torture, right? Is the production of the paper, not for paper's sake, but precisely to make it not a physical practice. The paper looks voluntary, right? And as this German judge says, you can put in all this, like on the one hand, on the other hand, stuff, you know, that, I mean, because I'm sure when people are tortured, they say contradictory things, and that becomes ironically a marker of the truth of it. So I think paper is an artifact of the separation of the practice from the information.
I had a question about whether, you know, a lot of the people that we're talking about were arrested, you know, in a sense, a while ago. I'm just wondering if now, with all the, you know, sort of, at least from the Bush administration or perhaps the British administration's views as well, the liabilities of Guantanamo now far outweigh the benefits. You know, but so what about all the people that are being arrested now and their identities are, in a sense, not known, and presumably a future Khalid Sheikh Mohammed will never even be known, in a sense. Is there anybody who's being held overseas now whose information is available, or is that stuff actually just completely precluded from even ever making it to courts?
Oh, goodness. Well, I mean, the first thing is I have to say that I'm on record as one of the people who really doesn't want Guantanamo to be closed.
Oh, indeed.
Right, because that's one of the few places where we might get legal supervision of this process, and if you ship them all to Bagram, you're never going to get it, right? So I actually think that it would be better if everyone was sent to Guantanamo, or if Guantanamo's closed, that everybody be moved to the U.S., but that would be the only circumstance under which I would advocate closing Guantanamo. So one of the things the Bush administration's obviously tried to do, and actually a friend of mine who works at the CIA was saying, I mean, probably he shouldn't have been saying this to me at the time he said it, but when they were rounding up all these people, and he said, you wouldn't be surprised what we've been permitted to do, and then the day the torture memo leaked, he called me up and said, you see? I actually said, if you've been relying on this as a legal argument, you should, you know, stop it. And then he sends me an email the next day saying, read the Washington Post, and the headline in the Washington Post was, all these harsh techniques have been canceled. So, I mean, so they really thought that was a legal excuse. But anyway, so one of the problems that the CIA recognized from the very beginning was that there was no end game for this, right? You round up these people, you squeeze them, and then what? Right? So they were pressuring the Bush administration to have some trial process that would allow these folks, I mean, because in many cases, these really are people who should not be let go, right? And so the question is, through what process would ever legitimately produce a conviction that would allow them to be held on regularized grounds? And that's what I think the military commissions are moving toward. But because there's been this, you know, what you see actually, and I must say that, you know, as an evidence teacher and a concurrent pro teacher, you say this to your students, this is the best example of it. The individual rules may look really funny, but the stuff works as an integrated system, actually. And when you pull one thread out and you make a whole series of exceptions along one line, it affects everything else. So using coercion in this one spot means you contaminate all the possible trial processes. Right? And so I think what will eventually wind up happening is that there'll be some kind of military commission that will probably have to be forced not to use coerced confessions. Whether they use coerced third-party statements is I think where all the action is. But yes, there's still people, there are now new sites, I think we're all pretty confident about this, that there are new sites that new people have been detained in and have been put elsewhere. The Bush administration appeared to clear the deck so that all the investigative journalists would go away and they dumped the worst of the worst into Guantanamo. But there are clearly new sites and there are new people being detained. And I think they're trying to work out, I mean, they've clearly realized that they have to keep them secret, keep the sites secret, and probably disappear them at the end of it all. It's the pump and dump, you know, back to that again.
Could you speak a little bit about the kind of reverse idea, which was a big trial here in Chicago recently of a Palestinian activist. And they because he was originally tortured for 80 days in Israel, the confession was not held to the same standards as it would be if there were a confession taken by U.S. agents. So we had this secret motion to suppress where unnamed Israeli agents came to this country and the judge then listened to them in secret and we couldn't hear what their testimony was, on and on and on. But the point is, with that kind of confession or a rendition type of statement or one taken by an Egyptian torturer, you have the same kind of effect as what you're talking about.
Yeah, this is actually, I mean, a hot topic for American constitutional criminal procedure. The globalization of criminal procedure has not yet happened. And in fact, U.S. courts have really struggled with this question of how much of the Constitution applies extraterritorially. I always want to say extraterrestrially, but so for example, it's even unclear, certainly with confessions in foreign countries, it's certainly the case that people are not held to Miranda-type notice. It's not even clear that confessions off U.S. territory of non-citizens are held to Miranda-type notice, even if it's FBI interrogators doing it. That's to show you how. So there's a lot of cases that are trying to figure out how far does the Fourth Amendment extend, how far does the Fifth Amendment extend to the production of evidence abroad. And the courts are totally at sea about this. And so what they tend to do, and the State Department often intervenes in these things and basically says, if you don't believe this, it'll disrupt foreign relations. And there's some undercover motion that goes to the court basically saying, believe this or we'll never be able to talk to Israel again and it's too important for us to talk to Israel. So it's a really important area. The doctrine on this is not settled. And there have been too few cases that are too different from each other to show a real central tendency on that. But I think you're absolutely right. One of the things I'm very worried about, though, in context of the war on terror, is what I call the torture division of labor. There's a case of this guy, Abu Ali, the guy who was convicted of plotting to assassinate President Bush, an American citizen. You may have missed this case. It went by really fast, but this was an American citizen studying in an Islamic school in Saudi Arabia. He was arrested out of the library in his school and held in a Saudi jail, interrogated by Saudi investigators day and night for a very long time. He apparently admitted to not liking President Bush and wishing that President Bush were out of office. In the meantime, his right, exactly. In the meantime, his parents, who had some communication with him, learned that he was told by one of his guards that he was being held there because the U.S. wouldn't allow him to be let go. This is an American citizen in Saudi Arabia. So his parents file a habeas case in Washington, and the judge, on the basis of the evidence the parents put forward, say, there's enough evidence to believe that the guy's being held at U.S. behest in a foreign country, and they started down the road toward scheduling a habeas hearing, and suddenly the guy is airlifted back to the U.S. and charged with attempting to assassinate President Bush. And it's on the basis entirely of things he said in Saudi custody to Saudi interrogators. Okay? He claimed that this was under coercion and torture. There was a closed hearing about this, after which the judge ruled that there was no such coercion. And the only evidence against him were his own statements to the Saudi interrogator. So what I'm concerned about is that the rendition program and these kinds of cases show that one of the ways the U.S. has been trying to handle these cases is to get somebody in jail into a foreign country where the Constitution doesn't apply and where coercion can't be inquired into too closely for various kinds of diplomatic reasons. Then you bring the person back here, you put them on trial, you convict them here, even in the cases of American citizens. So there's a kind of division of labor where their country does the torture and we do the convictions in court. So it's a bigger problem, and that there's an increasing number of cases that have that general shape.
I know there are many more questions, but unfortunately we're out of time. Scott gets the last word, but before that, let's thank him.
2 more minutes or so. First thing, very quickly, if you are a presenter here and we have not exchanged paperwork yet, and you are going to leave this town, you need to exchange paperwork with me in the very near future. Second of all, I want to thank all of the speakers because they have been so terrific over the course of these days. And there's a little bit of a story with this. If you had any idea how little I knew about torture, which was even less than I know now, a couple, 3, 4, or 5 months ago, you would not imagine that we would get this range of great speakers together for this kind of conference. And so besides having given great talks, I want to also point out some of them, especially like Darius Rajali and Lisa and Kim, have given me great feedback, as well as others I'm probably going to forget to mention, as to who to talk to, who to invite, all these sorts of things. They have been very, very helpful to me because I could not have thought of this altogether. But it's also, of course, the case that none of them would have come if just sort of like guy they've never heard of before sends invitation to come to talk at the University of Chicago in the winter. And of course, the reason why they came is because the stationery says Martha Nussbaum at the top. And at the bottom it says from Martha Nussbaum and Scott Anderson. And the invitations are from her. And she has been a great guide and friend and mentor and the efficient cause of this position here existing, and the fact that the dean would trust me with budget, would like go spend money, bring people here, is because she is sort of like the good housekeeping seal of approval on academic effect events. If she's behind it, you know that it will be good. People will show up and think that it's fabulous, and in fact, they were right all the way top to bottom. So thank you, Martha, for your support and for all of the work that you did with it.